When it comes to the courts, particularly in the private family court proceedings, anything less than perfect can be scrutinised, challenged and used against a protective parent. And at the very same time, a perpetrator can continue to bring forward allegation after allegation, even when those allegations have found to be unfounded. Repeated allegations, repeated challenges and relentless pressure. That imbalance cannot be ignored. And what is happening? The fight for her life, the fight to protect herself and her child, is playing out in a courtroom, while the person who caused that harm gets to sit and watch and take serious satisfaction from it. That cannot be what justice looks like. We also know, and the evidence now confirms, that coercive control does not end when a relationship ends, and far too often it finds a new platform through the courts. Litigation itself becomes a tool of abuse, not in the interest of the child, but as a means of maintaining control. And we need to talk about what that actually looks like in practice, because women have come forward to say this. On a Monday, they are granted a 12-month non-molestation order, protecting them from direct and indirect contact from their abuser, and by the Wednesday, they are sitting just feet away from the same abuser in a courtroom, expected to engage, expected to respond and expected to remain composed, and then ordered to communicate through a court-mandated parenting app, creating yet another channel of communication and control. That contradiction is stark. Litigation can be misused, and even when the misuse is so clear and the pattern of behaviour is so obvious, it is not treated as a crime, because in the eyes of the law, the correct avenue is taken: the court process. She is left in a position where she is technically protected, but only by a court order that can be broken, that relies on the behaviour of someone who already has demonstrated that they do not recognise boundaries and they do not respect authority. And she sits there completely alone, because the patterns of behaviour are not recognised, because systems do not join up, because there are still gaps in training, gaps in understanding and gaps in how coercive control is recognised across the system. If victims are leaving airports feeling re-traumatised and children are not being adequately heard, if perpetrators are able to continue patterns of control through legal processes, we have to question: are we truly delivering justice, or are we allowing harm to continue in a different form?